Welcome to the Ranting and Raving About Real Estate podcast, where we discuss how real estate can shape your future and build your financial freedom. I am so excited about this episode of today's podcast. It is going to be about estate planning, and today's guest is none other than attorney D. Sibley. D, welcome to Ranting and Raving About Real Estate.
Thank you for having me. I'm so excited about being here today and having the opportunity to talk about the combination of estate planning and real estate. It's so important.
It is. So I just kind of want to start off just letting everyone know about how I met you. And so actually, my first encounter with you was actually on social media. And so I saw a piece that had, your picture, D. Sibley, estate planning attorney. And I was actually thinking about, I need to do some estate planning and all of a sudden you popped up. So I learned about the different seminars that you offer. I believe it's on a monthly basis.
It is on a monthly basis that we coordinate, but then I also do speaking engagements when requested. So it may be a couple times a month.
Okay, awesome. And so I even went, I believe it was either to your YouTube or to your website, and I saw this story that you told about a pearl necklace.
Yes.
And you told the story about your grandmother had a desire for you to have this pearl necklace. And when she passed away, you did not receive that pearl necklace. Can you tell me a little bit more about that?
Sure. So that was my first introduction to estate planning and what estate planning can do and sometimes the way it goes wrong. But my dad had sent my grandmother, his mom, a pearl necklace and earring set when he was in Vietnam. And being his oldest daughter, she had told me that when she passes on, I would receive that. I was 9 years old. So as a young girl, those pearls symbolize just the stature. You think about Jackie O and now Michelle Obama. And so I really look forward to receiving that. Certainly, wanted my grandmother to be with us here always, but just knowing that she cared enough that it was going to come to me. So as you can imagine, when she passed on, I did not get it. Someone else in the family, we don't know who, got the necklace and the earrings, and I was quite devastated.
Yeah.
Because I looked forward to it. We had conversations, and she had also let other family members know that that was to come to me. So when that happened at a young age, I realized that sometimes the process does not work the way that we think it will or the way that we want it to. So that left that first mark on me about estate planning and how plans can go so wrong. And then over life, there were other things, but that was my first introduction to estate planning.
Yeah, and I think so many people can probably relate with your story where they've either personally experienced something like that or have seen it happen to someone else where they knew the wishes of a loved one prior to them, passing. But after that, their wishes were not honored.
Right.
So that's why I really wanted to have this episode with you. And another thing that really stood out to me in your seminar was like, okay, how many of you have like a will or some type of estate planning? And so some of the people in the audience raised their hand and some people did not. And you said, whether you raised your hand or whether you did not, guess what? There is a plan that's in place for you. It's either the one that you put in place or either the one that the state is going to put in place for you. So who do you want to decide how your assets are divided up? Do you want to be the one to decide or do you want the state to decide for you?
Absolutely. Man, you did very well.
Yes, am I a good student?
Listening. Yes, she was. And I love doing that because so many times people don't realize that there is a plan that you're going to inherit
Yeah.
if you don't put one in place for yourself. So it gives them an opportunity to compare
Hmm.
and make that informed decision because that's what estate planning is about, making informed decisions.
Yeah, yeah. And so, as a realtor, and I encounter, different clients from all
Mhm.
walks of life. And I always want to make sure that I provide my clients with the best information that is going to help them not only when they're buying, selling, or investing in real estate, but also beyond that. So, why is estate planning important for homeowners?
So, one of the best ways to think about this is a lot of times for us, our
Hmm.
home can be our largest investment, whether it's our initial home, whether we're, moving up to a home that we gives us more room, more space, or as we grow into those more advanced purchases of home. That because it's the largest asset, we want to make sure that we are protecting it, but we also want to make sure that we're able to provide that asset to pass to our beneficiaries or our heirs in a way that is the most least resistant. So I really try to emphasize when speaking with people, when you are a homeowner, you check the box, you have an asset and you want to make sure that you're passing that asset in a way that gives the most benefit to your loved ones.
Yeah, I totally agree with that because we work so hard, you know
Mhm.
what I'm saying, to
Mhm.
get that home. And that is what some people call the quote unquote American
Mm.
dream, is
Right.
to own your own home. So you purchase that home, but you don't have any plan for the future of how that home could be potentially passed down. So that is why estate planning is so important. And
Mhm.
then one of the things that I hear all the time is that estate planning offers protection. So, what would you say about the protection that estate planning offers? And I know you said something about it is offers the least resistance. Did I get that correctly?
Mhm.
Elaborate on that a little bit.
So when I say the least resistance, I'm talking about you want to be able to pass that asset in a way where it's not difficult for your beneficiaries or heirs to
Mm-hmm.
receive it. It is the most cost effective way of passing it. So when we think about with no planning at all, if you take no action after you own that property, and especially if it's your homestead property, when you take no action, then your estate is likely to go through probate
Mm.
because 9 times out of 10, and probably 9.9 times out of 10 now, that asset is valued at least $75,000. With it being valued at 75,000 and up, then we're going through what we call formal probate, meaning you have to hire an attorney. It
Mm-hmm.
has to go through the court process. And so we all know the court process is not free. It's not free to hire an attorney. It's not free to go through with the court filings. And it is a time factor
Yeah.
involved with all that. So when I talk about the path of least resistance, if you have an opportunity to pass that largest asset, remember your home,
Mm-hmm.
to your loved ones without having to go through court, without having to hire an attorney to do it, and without having to go through a long, drawn out period, that is the best avenue to be able to do that. So it's the path of least resistance.
Resistance, yeah,
Hmm.
and I've dealt with, clients that, have had a trust or some type of estate planning in place, and some that have not, and those that do not have an estate plan in place, like you say, they have to go through, probate, and that can be very costly,
Hmm.
to them. So for those that do not have, like, a plan in place, just think about it. If that property has to go through probate, and the money that they have to spend for the probate, that's money that your beneficiaries are not going to receive because they had to spend that money.
Right.
doing the probate process. Because, like you say, attorneys, they are not free.
No, we're not free.
Yeah, so I just like to also tell people about that. And one of the things that I want to touch upon, and we've had this conversation before, is that sometimes what people try to do to make sure that everyone in the family has a part of their legacy, which some people believe is their home, is they'll put like 5, 6, 7 different names on a deed.
Right.
And that has caused like so much trouble when it comes to the probate process and also when it comes to selling a home. Because when you try to sell the home, what? All parties have to agree.
Have to agree. Correct. Correct. And so when we're talking about estate planning, especially for real estate ownership, I want to be clear that there are ways that's part of your estate plan that you can still transfer that home ownership when you're no longer here. That's beyond or outside of a trust. A trust is one method of being able to transfer ownership to your loved one. So it really depends on your goals. But there are other kind of deeds, especially in Florida, because we have the benefit of homestead protection and
Hmm.
homestead exemption. That so often our homeowners, our people here are not taking full advantage of. Every state does not offer that. So because Florida offers it, we really do a disservice when we don't make ourselves available to all of those resources for passing those assets. So we can pass that home through a certain kind of deed. And as you mentioned, I've had people that have come in and maybe they've gone to, a different service, or they've done a DIY, do it yourself kind of deed, and they put 5 or 6 children on the deed, on
Don't
their
do it.
property.
Don't do it.
And the first question I ask is, honorable, you want to make sure that all of your children, get an equitable share. I say, but how were they growing up? Did they always get along? I have just two sons, adult sons myself, but they did not always get along.
Right.
And then I asked, now as adults, and everyone is, having their own life, how do you think they're going to get along sharing this one property with their different stages in life for whoever knows how long?
Mm-hmm. Mm-hmm.
So, a lot of times, eyes will widen up and be like, well, I want them all to have a share. And yes, they'll all have a share, but is that going to cause conflict
Yes.
later? That's the question. Because to have a share, but then to fight about, two of them want to sell it, one of them want to keep it for a vacation home, a third one may want their, son or daughter to live
Mm-hmm.
in it rent free. That can be conflict. So I part of what I do is we talk through these things because I don't want to do estate planning for my client sitting in the chair today because
Mm-hmm.
it's very easy for me to do that deed, only to know that 2, 3 years down the road or when the time comes, now there's this big fight because 1, 2, 3, 4, or all 5 of them are fighting about what gets done with this one property that
Yeah.
they all share.
Yeah. So can I just keep it real for a moment?
Absolutely.
Okay. So I'm going to look right in the camera.
Mm.
And some of you know when funerals happen or after the fact, that's when the biggest fights start. No, mama wanted me to have this. Mama
Oh,
wanted this. Daddy wanted this. But nobody really knows because mom and dad's wishes have not been written out or put in some type of formal document.
right.
So earlier you mentioned about a trust. So what exactly is a trust?
So I'm going to simplify this a lot because a trust, and we're talking here about a revocable living trust, what we
Mhm.
call the RLT, is a complex concept, but we can make it so much easier by breaking it down in steps. So I want you to think about a treasure chest.
Mhm.
Okay. The treasure chest will symbolize your trust.
Okay.
And when we are creating this trust, we're going to write a book basically. And in this book, we're going to talk about where you want your things to go, when you want it to go to them, how you want it to go to them. For instance, do you want them to get it all at once? Do you want to spread it out over 10 years? Do you want to create some legacy? Do you want to start to plan for grandchildren that you may not even know today? So, in this treasure chest that we've created, we are now writing the book. And once we are done creating this, we're going to put the book in the treasure chest.
Okay.
While you are alive and have capacity, so you have to have capacity and be alive, you control that treasure chest. You can open it when you want, you can close it when you want, you can make changes, you can totally revoke it,
Okay.
meaning you can totally say, I don't even want this treasure chest anymore. But once you're no longer here or you no longer have capacity, as part of that book or the instructions, you've also said, when I'm not here, my successor trustee will now manage the assets in my treasure chest and give it according to the directions that I've written, that book that
Mm-hmm.
we talked about. So that's how you're creating this framework for your assets and protecting them for your beneficiaries when you're not here. Now, after we create the trust, we set it up. The second step is you then transfer the assets out of your individual name. So, for instance, my bank account may no longer be in the name of D. Sibley. It may be in the name of the D. Sibley Revocable Trust. Or my home may no longer be in the name of D. Sibley. It may be in the name of the D. Sibley Revocable Trust. So the way we avoid probate is when I pass, it's not in my name anymore.
Mm.
It's in the name of the trust. The trust continues when I'm gone. It continues because my successor trustee now has the instructions on what to do with those assets. So it is a way of avoiding probate
Mm-hmm.
as long as your assets are titled into the name of your trust, either directly or indirectly.
Okay.
Okay. Because probate is the court's way of transferring your assets that are in your name only or has no beneficiary designation.
Mm.
But because the trust, now the assets have been changed to the trust, it can continue on without ever having to go through court, without ever having to worry about that level of conflict that we see through the court process, through the probate process so very often.
Mm-hmm.
And also think about a trust is a way to build that legacy because as I mentioned, you can create a children's fund for your grandchildren that you may not even know today. You can decide how you want your loved ones to receive those assets over time, over different stages in life. If you can think of it, then we can put those things in place. So that's a very high level of
Okay.
what a trust is.
Okay. Okay. So that was a lot.
I know. I said it's a complex concept,
It
but
is.
you
And
take
that's
it in
why you need
small.
an attorney, right? For complex
Absolutely.
matters such as this. So just so many questions have come to my mind since I said that. So first, what I want to ask is, what if someone says, you know what, that's too complex for me? Why can't I just get a simple will versus a trust?
Well, you can. When you have a will, then you're going through the probate process because a will when you have a will, your assets are still in your name
Mm-hmm.
until you pass away, right? And then the will allows the court, based upon your will, those instructions of how to pass those assets. So you can certainly have a will. In fact, when you have a trust, you still have a will. We call it the catch-all will, the pour-over will. But the difference is one, with a will, you're going through probate, so you're going through the court process.
Mm-hmm.
With a trust, you're not going through court and probate as long as all your assets are titled to the trust. And also with a will, it is what we call an outright distribution. So what that means is if I am leaving my two sons $100,000 each in my will, once we finish the probate, the court process, there's going to be a court order signed by the judge that says Bob and John now has the $100,000 that's in the bank account.
Okay.
That means that Bob and John is getting a check for $100,000. Hope they don't spend it all in one place in one weekend, and it's done. When we do a trust, I may say in my trust, the money that's in the bank account that's in the trust will go to Bob and John, but instead of $100,000 for them to spend all at once, I want them to get $10,000 each for 10 years because I want to spread it out.
Yeah.
I want to provide them with some protections that I haven't even really touched on, but as long as it's in the trust, it's in there in a protected fashion. So when we're setting up your trust, that's one of the things of many that we're talking about. What kind of protections do you want for your beneficiaries? What and how should they get this? Is
Yeah.
there certain conditions that need to be met? Or do you want them to get it outright? So a will certainly has some benefit, but it's very different than having a
A
trust.
trust. So what I hear you saying is if you have a will, yes, that is still a good tool
Mm-hmm.
to have, but understand that your estate will still go through the probate process with a will versus if you have a trust, it will not go through the probate process.
Correct. If you have a trust and you have funded your trust, we call that funding your assets to the trust.
Okay.
Because remember, that's important, that second step.
Okay, D. So I can't even get to my other questions because now you just brought up another one. So funding a trust. So what does that mean when you have to fund a trust?
Okay. So in our scenario, we've set up our trust,
Mhm.
right? It's all set up, we've done the signing ceremony, which makes it the official trust entity. And so now the next step with my clients is, all right, we are now looking at all the assets that we talked about in the beginning. So the home, for instance.
Mhm.
Now we need to title the home into the name of the trust. So I'm going to take it out of my personal name. And now I'm going to say it is now owned by my trust. And that's why it does not have to go through probate. Because remember, probate is how the judge signs the order to pass your assets. But he doesn't have to do that. He or she doesn't have to do that because the title to the home is in that trust. That trust goes on even when I'm no longer here.
Okay, so I think it's starting to kind of make a little sense to me. So you started off saying that the trust is like a treasure chest.
Mm-hmm.
And so with the funding, now you can't have an empty treasure chest.
Absolutely.
So we need
You
to
got
put
it.
some treasures in the chest.
We do.
Okay.
Oh, she got it.
Ding ding, go girl.
Yes. And the book, the actual trust that we've done, the rule book, if you will, is telling how your successor trustee is going to take those assets out of that treasure chest
Yeah.
and who he or she is going to give it to and when and under
Okay.
what conditions.
Yeah.
So you're writing the playbook of what's to happen when you're no longer here to do it yourself. And you've assigned who that manager we call successor trustee is going to be, who that person will be to do it.
Yeah. So another thing that came to my mind, so you talked about the book and writing the story. And so with a revocable trust, while you're still living, you can rewrite that story.
You can rewrite it every day if you want to. I don't advise it, but you can rewrite it as much as you want. And as you're still living and life is still progressing, your assets may change, your designation of agents may change, your beneficiary listing may change, and you can make all those changes.
Great, great, great. Because I think some people may think, okay, well, if I get a trust, then I can't change that trust. And what if I want to make some changes to it? But that's not true. You can actually make changes. And I believe it's recommended that you do periodic updates or periodic
Review.
reviews of the trust, just to check to see if there are any changes that need to be made.
Correct. So that's what the revocable, that's
Mm-hmm.
what that means, that you can revoke, amend, modify it anytime you want, as long as you have capacity and as long as you're still living, right? And we do recommend that you have a periodic review. For my clients, we do a periodic review every 3 years
Mm-hmm.
because the laws may change that could affect your trust. Your beneficiaries may change, or just how you want the structure to be may change. So you don't want to write this book that's so very important and put it on a shelf for 20 years and not touch it. Because then in 20 years or so, when your successor trustee needs to crack open that book and look at those instructions, you want to make sure they're still relevant
Mm-hmm.
for what you want to have happen. Absolutely.
Right. And I love the way you put instructions, because we know our family better than anybody else. And
Mm-hmm.
if we have children, we know our children better than
Mm-hmm.
anyone else. And sometimes if you have a large estate that is valued at, let's say, a high amount, right? You may have some people that are listed as beneficiaries in that trust that can't handle a certain amount of money or all at one time. So, like
Absolutely.
you said before, you want to make sure that they're not receiving everything up front and just blowing it away. So, I like the way you talked about the instructions and how you can designate certain beneficiaries to receive certain amounts of money or whatever at certain periods of time. So, another question that comes to mind is very important who you put, I guess, as the successor trustee, to make sure that they are going to do the right thing as it relates to the managing of the assets and the funds. Are there any, I guess, recommendations or suggestions or advice that you can give as it relates to who someone puts as a successor trustee?
Absolutely. So there's a series of questions that I would normally go through when I'm working with my client to do that designation. So there are certain skill sets that
Mm-hmm.
you want to consider, right? You certainly want someone that's organized, someone that's dependable. You want someone that you can trust. And when we're designating who that might be, we're also looking at a successor to the successor,
Mm-hmm.
right? If there's no one in your immediate circle that comes to mind, then we can do what we call the professional trustee situation. So banks can be trustees. Sometime your CPA can be the trustee. Attorneys can be the trustee. So there are the professional networks. I like to encourage my clients to let's look at your circle first.
Mm-hmm.
But if we exhaust all that and don't have anyone that you want to put in place, then we can look at those independent professional trustees. Um, just keeping in mind that that's going to come at a cost to the
Mm.
trust, right?
Okay.
Because they will have their fees. And sometimes they want to have a trust at a certain level, especially the banks and financial institutions like that. But you certainly want to look at who is trustworthy and who you can depend on. When you designate who that successor trustee is, they have the opportunity to hire a CPA
Okay.
to help them, to hire an attorney to help them. So they have to their disposal the opportunity to hire those professionals to help manage the trust. So those are all some things that you want to keep in mind.
Okay. Now, is there anyone that you would say does not need a trust?
So when I'm counseling with clients,
Mm-hmm.
it really depends on a lot of different factors. There may be times when what they want to achieve
Mm-hmm.
and with the assets that they have, we can achieve it with a family-based plan. The plan that will go through probate. At that point, what we're looking to do is to minimize what has to go through probate. So we want that probate avoidance,
Mm-hmm.
right? But a trust is not going to be the best fit for everyone. And so you really have to look at a lot of different factors, which is why it's important to go over options. You can't get to those options until you kind of educate on what you have, what your goals are, what your family dynamics are. Like you mentioned, we know our families better than anyone else,
Mhm,
right?
mhm.
Sometimes we need more structure. Sometimes we may be okay with less structure. Sometimes your assets, depending on how title is held on those assets, we can achieve what you want to achieve without having to do a trust.
Yeah.
Because there's a higher cost to do a trust than to do the family plan, but there's more protections when you
Mhm.
do a trust. So we always have to weigh how can we achieve the goals with the least amount of resistance.
Yeah.
Okay. So that's one of the things that I really work with my clients on. We have to look at your goals. We have to look at your family, which is why I say there is no one size fits
Fits
all.
all. I
There
totally agree.
absolutely is not. Every family is different. Your assets are different. Your goals are different. So you have to find what works best for you and your family.
Yeah. And I'm just going to be like completely transparent. What you mentioned about family dynamics,
Hmm.
that plays a very important role because if you have blended families, that can sometimes, when you're sitting down doing your estate planning, cause a little friction. And whoever you're doing the estate planning with, there has to be like a meeting of the minds is what I call
Right.
it, as far as how you want things to go. Because even with that, some families can, initially not agree on, okay, I want, this child to get this, or I want
Hmm.
this child to get that. So it's just different conversations that need to be had as it relates to that. And being the attorney and dealing with different clients and different, family dynamics, I'm quite sure you've probably seen like some scenarios, in that instance. And so my husband and I, we have a blended family.
Hmm.
We went through the estate planning process. And so there are some things that we had to talk out to make sure that both of our wishes were included in the instructions as far as what we want. So I think that is why it is so important to have that protection so that everyone knows what your wishes are and those wishes are adhered to.
Right, right. And you know what? That is an excellent point. And what I like to tell my clients, especially when we're talking blended families, when we're doing your planning, let's start to facilitate those conversations.
Hmm.
Because the more that we can have that open conversation and kind of talk through the options and then put that in your plan, the less conflict there's going to be later on with the
Hmm.
family, right? Because if we're designing it in such a way that the ambiguity is removed, you're clear on what you want to give, when, and how, then the children or, other family members don't have to fight because it is clear. They may not like it. And I tell my clients this all the time. We're doing estate planning for you.
Hmm.
We're talking about your wishes. Now, what your children may want, they need to do their estate planning.
Hmm.
But when we're in the office, we're talking about what your goals are. Because remember, we're talking about your assets, your life. So, I certainly encourage my clients to factor in their children and their family, but we're doing your plan. So I want you to have conversation. You tell me what you want, and I'm here to help put it in place. Um, and think about the more you put in place now, the less they're going to have to fight about later on.
Mhm, mhm,
So
mhm. That is, so good. So, so many different things come to mind because even as it relates to, you mentioned first revocable trust, but there is also such a thing as an irrevocable trust. Can you tell us the difference between the two?
I can. So an irrevocable trust is just that. Once you put it in place, you cannot change it. When if you want to make a change on an irrevocable trust, most often you're going through court. You basically have to ask the judge, can I change this? Because you put it in an irrevocable trust. Now, there's some benefit to an irrevocable trust, but think about that treasure chest that we were describing for
Mm-hmm.
the trust. An irrevocable trust is when you put those assets in that treasure chest, you just locked it. You cannot go back in there and change it. You cannot go back in there and pull it out. You can't put that bank account in there and say, "Oh, I'll come back and get something from it later."
Mm-hmm.
That's not the way that works.
All right.
So, when considering an irrevocable trust, there are certain times and there are certain kinds that we would really walk through because you have to be ready to relinquish those assets. You think about it in terms of those assets are in there for your beneficiaries ultimately, and you no longer have access to them. So you
Mm.
really have to know that I don't need, that be able to change that house or access to that bank account or access to those annuities or anything like that.
Mm-hmm.
So it is quite different, but it is applicable and appropriate in the right situations. I don't see nearly as many of the irrevocable unless you are in later stages in life.
Got it. Got it. Got it. Now, I've heard this often from people. They feel that putting their home in a trust will protect them from lawsuits against the home or different things of that nature. And from my understanding, if it's in a revocable trust, that doesn't necessarily protect it from lawsuits or anything like that.
Right. So remember, I mentioned with Florida having such great homestead protection,
Yes.
right? So Florida homestead law gives us great protections for our home. There's only certain circumstances where a home can be attached. Creditors is not one for your homestead property.
Okay.
So whether you put your home in a trust or even if you're not doing estate planning in terms of creditors, although there are certain times, of course, IRS can always put a lien on our home,
Mm-hmm.
right? Mortgage company, we give them that right when we do the loan. So that the taxes and things like that, and then mechanics liens, of course.
Mm-hmm.
But other than that, you don't have that issue for your homestead property in terms
Property.
of creditors. Now, when I meet with clients and we're looking at again their goals,
Mm-hmm.
what their assets and how they own them, we're going to be talking through, is it feasible or the best in your circumstances to put the home in a trust, or is there something else we can do to give you that same protection and avoid probate? For instance, one of those deeds that I talked about, what we'd like to call the ladybird deed.
Mm-hmm.
Florida has the ability to do a ladybird deed. They're not appropriate in every situation,
Mm-hmm.
but for quite a few options out there for people, it can be one of the best resolutions and ways to avoid probate without having to put the home in a trust,
Mm-hmm.
but being able to pass it to your loved ones when you're no longer here. So it will depend. I don't typically recommend that if we're talking about putting 6 people on the
Mm-hmm.
deed,
Mm-hmm.
but under certain circumstances, and I've used it a lot.
Got it.
I've used it a lot. Can I share one scenario that I've seen quite a bit that is not
Of
feasible?
course.
So I've had people to come to me and say, I need your help because I put my son or daughter's name on my deed because I was told by a friend or someone that that's the best way to avoid probate. Almost like what we talked about the ladybird deed, but what they did is put their child's name, their adult child name on the deed right now, right away. That's very different than a ladybird deed. As a consequence, quite often they lose their homestead exemption
Mm.
because that adult child does not live in the home.
Mhm.
And so when they went to pay their property taxes, their taxes went up because they no longer had that exemption, right?
Yeah.
In addition to that, they've now made their adult child also the joint owner of that home.
Mhm.
So if that adult child is going through a divorce or have any judgment problems, now they're half owner of the home and their home is no longer homestead protection. So that is one of the biggest mistakes I have seen happen. So what we have to do is do a new deed to undo that one.
Mhm.
And to do that, we have to ask that adult child, can mom or dad have 100% of their home back? I really had one situation where the adult child said, no, I'm not signing it back over.
Look, hush
It's
your
going to
mouth.
come to me one way or another, but they would
Wow.
not. There was nothing we could do.
Yeah, yeah.
Nothing we could do. So I really, when I'm doing my seminars, tell people, talk about it.
Mhm.
What worked for your neighbor may not work for
For
you.
you,
Their
right.
circumstances may be different.
Right. And that's why I always tell my clients, listen, I am a real estate professional. I cannot give you any legal
Mhm.
advice or any tax advice. So that's why it's very important that you consult an attorney when it comes to wills, deeds,
Mhm.
trusts, estate planning, things of those natures. So if you are listening to this podcast on today and you've been wondering, do I need to put a trust in place? Do I need to do estate planning? This is what I have to say is that you've worked hard for the treasures that you've accumulated. And as Attorney D. Sibley said, a trust is like that treasure chest that's going to protect the assets that you worked so hard for. And you want to be able to put those assets into that treasure chest so it can be protected and not go through the probate process as it relates to the home that you own. Now, I want to kind of do like a little segue to some of the other things that you mentioned that are a part of estate planning.
Mhm.
So you mentioned, I believe it is called a living will
Mhm.
or healthcare directive, things of that nature. So talk to me a little bit about that.
Okay, absolutely. One of the things I like to tell people when I'm doing the seminar is I like to debunk myths.
Mm-hmm.
And one of the biggest myths that I see as it pertains to estate planning is that people think it's all about passing their assets when they die, right? So they'll say, well, I'm going to do that. I already know where I want these things to go. And even if I do a will, it'll be taken care of. And I like to tell them that it's 50% about passing your assets when you die, but
Mm.
it's also 50% about protecting yourself while you're living.
Okay, can we say that one more time for the people in the back? So no, that's good information because like you said, people feel that estate planning is only about, when you die and passing on assets.
Correct, correct.
You said it's only 50% about
It's
that.
only 50% about passing those assets. The other 50% is taking care of yourself while you are living. So when we talk about a healthcare directive, the healthcare directive is the legal document that says if I cannot make medical decisions for myself because maybe some period of incapacity, some medical issue, here are the people that I have listed in order that can make those medical decisions for me.
Mm-hmm.
Without that, there's the opportunity for conflict. So if you have a chance, look up the Terry Schiavo case. This was a case 20 years ago here in Florida that went all the way up to the Florida Supreme Court. And that case really showed how important a healthcare directive is. So we're talking about, the first thing, that healthcare directive, who can make those medical decisions for you.
Mm-hmm.
Another one is the living will, as you mentioned. A lot of times people hear living will and they think of last will and testament. Two different options here in estate planning. The living will is also called the advanced healthcare directive, and think about that as your last wishes.
Mm-hmm.
This is the document that says, for instance, I don't want to be on life support for an extended period of time. And you get to say what that extended period of time is. You may not want to be on life support past 5 days. You may say that, keep me on life support until my children can get to my bedside, which is one of the ones that a lot of my clients do, especially when they have adult children that live out of state.
Right.
So it's really your last wishes
Hmm.
about what's important. And what is important about that is you're making those decisions and taking that weight, taking that struggle off of your loved ones at such an emotional period of time. And I have seen so many times where it creates that in itself creates family conflict
Yes.
because son may say, no, keep mom on life support till eternity.
Mm.
Daughter may say, mom and I have talked about this. Although there's nothing written, she would not want this.
Hmm.
So you can have your children, your spouse at conflict about what you would want to have happen.
Right.
Again, this is how you're taking care of yourself. A power of attorney, durable power of attorney is the document that says, here's the person I've listed as my agent, my
Hmm.
financial and business agent, so that they can handle my financial and business affairs on my behalf. So having that person, having that document
Yeah.
done and done properly will allow them to be able to access the bank account, certain bank accounts,
Hmm.
whatever you designate, so that they can make sure that your financial and business affairs are still taken care of, especially when you're not able to do it yourself.
Yourself. Yeah.
Um, we have the HIPAA waiver.
Hmm.
This is one that we're pretty well accustomed to. We sign the HIPAA release when we go to the doctor's office. I say the HIPAA waiver is like that on steroids.
Mm.
That HIPAA waiver is the document, that one legal document that you can take to a hospital, to a doctor's office, to any medical care provider and say, these are the people that I give the authority for you to talk to about how I'm doing. They can have that access to my medical information. And so that's just one of the ways that that can be important. It's also can be important if there's any future lawsuits
Hmm.
for injuries. And then the last one on this list is what we call the pre-need nomination. And that's the document that says, if I'm unable to take care of my physical self, that could be the incapacity issues. It could be advanced dementia, anything like that. It's the document that says, here's who I name as my agent to be able to make those decisions for me.
Yeah.
Okay. This is what keeps your loved ones from having to go into court to get a conservatorship or a guardianship. So, you think about the Wendy Williams situation. You think
Hmm.
about Britney Spears, where it had to go through the court process because the court determined that they could not do for themselves. And so it was that long, drawn out process. So these are things while you are living to take care of yourself. And so sometimes people will say, well, that's okay. They'll make the decisions. Sometimes they have to go to court to get the legal authority to make that decision.
Wow.
So we're talking about spending the money,
Yeah.
right? Because you're probably hiring an attorney like
Hmm.
myself. You're talking about the length of time to do that. And then you're talking about what's happening with you while your family have to go through that process,
Right.
right? So that's time, money, and effort that could all be avoided with a
Yeah.
little pre-planning.
Yeah.
So 50% about taking care of yourself and 50% about passing your assets.
Yeah. And I think it's so important for people to talk about these things up front. You know what I'm
Mhm.
saying? Because uh a lot of people find it difficult to talk about death. A lot of people don't want to talk about it. Like if you bring it up, well, we need to discuss like what will happen. Like if I pass, oh, I don't want to talk about that. they're not going to be around forever.
Right.
You know what I'm saying? So these are conversations that need to be had. And again, I think it was so important that you emphasize that estate planning is 50% about when you pass away and, how your assets are going to go, but 50% about when you're still living or if you are incapacitated. And you mentioned about the healthcare directive and the living will and just making it easier for your family members so they're not fighting about, okay, no, I know that mom or dad would not want, for lack of better words, the plug to be
Mhm.
pulled in a 7-day period or a 30-day period. But other things that you need to take into consideration is the longer that you leave someone on life support trying to, argue these things out, there's a financial cost that
Absolutely.
is adding, up. And a lot
Mhm.
of times we're not taking those things into consideration. So I could just say for myself, when I sat down, my husband and I sat down with you
Mhm.
doing the estate planning and you brought these things up. And I'm just going to be a little humorous here because I was like, well, wait a minute, don't pull the plug on me too quick. Give Jesus enough time to do his work. So listen, I was like, give me at least, I think I said 14 days. And Derwin, he was like, oh, just give me like 3 days and, pull the plug. So, I say that in a humorous manner now. But like you say, you want to take the burden off of your family
Right.
members because going through such a difficult time as being incapacitated, there are, so many emotions that are going on and people may not be in the
Yeah,
right
right.
mind to
Right.
make
Yeah.
the right decisions that are going to be best for the family.
Right.
So,
Right.
Dee, I just want to thank you so much for taking the time to sit down with me today to go over why estate planning is important for our homeowners. What is a trust? I love the scenario about the
Thank you.
treasure chest, and then just different examples for people to consider. Before we close this out, is there like one last thing that you would like to leave with the listeners or those that are watching us today as it relates to estate planning?
First, thank you for the opportunity. I love talking about this because, as I say in my video, when we started having grandchildren, we had the 5 grandchildren, but when we started having grandchildren, that was that other epiphany for me that I
Mm,
want things different for them. And so I knew that because I wanted things different, that there were other people out here in the world that want to do better, do different for their loved ones as well. So that's one of the reasons I'm so drawn to this area. But to your question, I would say with the holidays coming up,
mm,
let's have some conversations. I have some guidelines that I can offer to help start those conversations about just what you want, how you want it, and let your family know you're doing some planning.
mhm,
Um, because when that time comes and they need to step up, it should not be in a vacuum, right? We want to equip them with some tools. It also can show you their mindset, who's strong enough to do X, Y, and Z. I had a conversation with my youngest son talking about our estate planning, and he got emotional,
mm,
which was so eye opening to me early on because I was going to put him in a role that once that happened, I decided, let me change, let me pivot because I know how emotional he was at that time.
yeah.
So I wanted to put him in a way that he's still important in our estate plan, but not put so much on him that it will burden him.
Hmm.
And so I say, as much as it may be a little bit difficult to have, the feedback that I get from clients, such as yourself, is that it's great when you know it's done.
Hmm.
It's a lot to think about going into it, but on the other side, knowing that you have taken care of yourself and your loved ones in a way that's important to you is monumental.
Yeah.
And so I want that for anyone. There's options.
Because I think it provides you with peace of mind.
Hmm.
Because
Exactly.
oftentimes, if someone is on their sick bed and they start thinking about life, they start, just in retrospect, looking at different things and then wondering, like, okay, are they going to carry out my wishes the way I want them to be carried out? Oh, okay, if I have a child over here that's not, from the relationship
Hmm.
that I'm currently in, is that child going to be left out? But if you put an estate plan in place, that is a way of you securing and making sure that your wishes are going to be carried out and you have that peace of mind.
Right. And none of us want to, those last moments, none of us know what those would be like, right?
Mm-hmm.
But who wants to be thinking in those last moments, are my children going to be okay?
Yeah.
Is my family going to be okay? I would imagine you want to be loving on them. You want them loving on you. You don't
Right.
want to be worried about, oh, I should have done X, Y, and Z,
Yeah.
because, how are they going to recover from this? So I think about that in terms of that peace of mind. And
Mm-hmm.
you're absolutely right. It's peace of mind.
Peace of mind. Thank you for tuning in to another episode of the Ranting and Raving About Real Estate podcast. Please remember to consult with a professional about legal and tax advice.